Good afternoon, everybody, and welcome to this St John's Chambers webinar on the Animals Act. Now, I hope there's going to be something for everybody in this talk. The difficulty with the Animals Act is that it's pretty esoteric, and many complaints have been made about it by the judiciary about how difficult it is to come to terms with. For those of you who have not had much experience of the Animals Act, I'm going to go through in some detail exactly what the critical components of it are, so far as establishing liability are concerned. For those who have more experience of the Act, I also hope that I can at least give some nuance to the issues that do arise just simply out of experience and the way that judges deal with these kind of cases. And the fact is that there are quite fine lines between liability and non-liability, and very often it comes down to the judge who is hearing it, their personality, their views on animals, their views on owners of animals, and quite what their approach is to the Act, and depends on their knowledge of the Act and whether they are entirely au fait with it. At least I'm up to date on this topic, having been walking last week in a field near my house where I met a woman who had just been knocked down by a cow. So I was able to give her a precursor to this talk. I don't think she was very pleased to have it, but anyway, it got me in the swing of things. So let us look at what the Act does. And I hope you've got some slides which are on the screen. Section 2.2 deals with dangerous animals and non-dangerous animals. Subsection 1 says where any damage is caused by an animal which belongs to a dangerous species, any person who is a keeper of the animal is liable for the damage, except as otherwise provided by this Act. Note there the term dangerous species and also the keeper who is potentially liable, and we'll look at the definition of those two things. Section 6.2 says that a dangerous species is a species A, which is not commonly domesticated in the British Islands, B, whose fully grown animals normally have such characteristics that they're likely, unless restrained, to cause severe damage, or that any damage they may cause is likely to be severe. Now, that's clearly dealing with the categories of lions, tigers, and such things. One might well have more interesting discussions about whether deer are commonly domesticated here, given the amount of deer farming that there now is. And furthermore, you might have a question in any event as to whether deer are likely to cause severe damage. But that's not the main purpose of why we're looking at the Act. We're looking to consider non-dangerous species such as cattle, horses, dogs, and such like. But let us look, before we go to that, the definition of keeper, because it's the keeper who is potentially liable under the Act. A person is a keeper of an animal if he owns the animal or has it in his possession. The subsection does go on, but this is the critical part of it and the one we generally have to deal with. He owns the animal. That is entirely understandable. It's clear, it's the owner. And someone also can be keeper if he or she has it in his or her possession. Again, that is tolerably clear, although one can come across a difficulty which in practical terms does arise in horse cases where a horse is kept in a livery. One has different kinds of livery. Clearly a livery in which the owner of the stables actually looks after the horse and rides the horse out or takes the horse out may well be in possession of the animal. In a DIY livery, the position may be different, in that it may only be on the basis that the owner of the horse is responsible entirely for the horse and the stable owner does nothing to look after the horse in any way. So it's questionable there whether or not there is possession in terms of control over the horse. The provision of fencing itself may cause one to look at the situation and say, well, actually there is some element of control there by the provision and maintenance of fencing. And indeed, I was involved in a case only a month or so ago in which a judge took the view in a DIY livery there was sufficient possession by way of control to render the stable owner a keeper. There are other authorities at first instance which paint a different picture, but it's at the borderline really between someone being a keeper or not being a keeper. The case of Flack and Hudson makes it plain that there can be two keepers of the animal at the same time. So for example, there may well be the owner and the person to whom she lends her horse who is riding the horse out when an accident occurs. In those circumstances, both keepers may have a responsibility and a liability. So that's the definition of keeper. Let's go back to look at the criteria for liability in respect of non-dangerous species. This is section 2.2, and there are three subsections, A, B and C, and we'll look at them in turn, but let me just take you through this section. Where damage is caused by an animal which does not belong to a dangerous species, a keeper of the animal is liable for the damage, except as otherwise provided by this Act. And that is a reference to statutory defences at section 5, which we will come to towards the end of this talk. So is liable for the damage if A, the damage so caused is of a kind which the animal, unless restrained, was likely to cause, or, and I emphasise or, which, if caused by the animal, was likely to be severe. So there are two limbs to A. The damage so caused is of a kind which the animal, unless restrained, was likely to cause, or which, if caused by the animal, was likely to be severe, that being the second limb. Subsection B has two limbs as well. The likelihood of the damage or of its being severe, so that's the reference back to A, was due to characteristics of the animal which are not normally found in animals of the same species, or are not normally so found except at particular times or in particular circumstances. And those characteristics were known to that keeper or were at any time known to a person who at that time had charge of the animal as that keeper's servant, or where that keeper is the head of a household, were known to another keeper of the animal who is a member of that household and under the age of 16. So don't worry too much about the wording of C, just concentrate on the first line there. Those characteristics were known to the keeper. One, as a claimant, must establish all three criteria under A, B and C. Now, what I've now set out in the next slide is what the criteria for liability is and what questions, when one's looking at a claim under the Act, one has to ask, and one has to go through it in a methodical way, step by step. The first two on this slide are the general questions. Has personal injury or damage to property been caused by the animal? Because those are the things which trigger a claim. We're dealing with personal injury in the normal situation. Is there a keeper of the animal, as defined by section 6.3. Who's the keeper of the animal? Is the one, is the two? Subsidiary question might be as well, is the animal wild, or was the animal once owned but now wild, such that it wouldn't be kept by any person at that juncture? But that's a pretty unusual for that aspect to be at large. So let's move on then to A. Was personal injury a kind of damage which the animal, unless restrained, was likely to cause? So, a horse which rears, was personal injury likely to be caused by rearing? That's the kind of question. Any kind of personal injury, but an injury. Quite often, it's the case that one can't prove that personal injury was likely as a result of a horse manifesting a particular characteristic. And so what I've set out at 3.4 quite often becomes the more important question and the easier link to establishing this particular element of liability. Was personal injury, if caused by the animal, likely to be severe? So take the case of the rearing horse. If a horse rears, you may take the view that injury is not likely to arise in the general run of events. But if injury is caused because somebody falls, the rider falls from the rearing horse, then that injury is likely to be severe. So those are alternative limbs of A. The claimant has to establish one of those limbs before one goes on to consider subsection B. Now, just looking again at A, you've all seen the word likely being used there. What does it mean? Well, the first meaning given to it was under the case of Smith and Angel, where Lord Justice Neal said it meant such as might happen or such as might well happen. Then in the House of Lords case of Mervahedi and Henley, Lord Scott, albeit obiter, said that it meant reasonably to be expected, although he did go on to say that that may not mean much different to the phrase such as might well happen. But certainly what has happened since Mervahedi is that the Court of Appeal appear to have accepted Lord Scott's definition of the word likely as being reasonably to be expected. And that's been the case in Freeman and High Park Farm and the case of Turnbull and Warrener. Whilst looking at definitions, the question often, I'm sorry, I've moved slides. The question often arises, what are you comparing the animal in your case to? It's quite simple if you're comparing a horse to a horse, but take the example of dogs. Are you comparing the dog you're concerned with to all dogs, or are you comparing it to, for example, an Alsatian, to a collie dog, or whatever? And the answer is that you should be comparing it to the nearest comparable that you can establish. So in respect of dogs, in the case of Hunt and Wallace, the court found specifically that the comparison should be with a collie dog, since the case was concerned with a collie dog. In Cummings and Granger, the issue was an Alsatian protecting a scrap metal yard. So one can see that one needs to consider the nearest comparable by way of subspecies or variety that is possible. Section 22A has been addressed in the cases that I have listed, and indeed it's been addressed in many other cases as well. But as I say, the case of Cummings and Granger was a case in which it was found that damage was likely to be severe because an Alsatian biting somebody was likely to cause severe damage, particularly where it's an Alsatian, because of the size of the teeth and the power of the jaw of the animal. Likewise, in Curtis and Betts, a case where a dog exercising a territorial instinct bit a child when the dog was sitting or getting into the back of a car. It's quite interesting that Section 22A has been the subject of a certain amount of dissent. And if you want to find a dissenting opinion, Lord Justice Lewison, in the case of Turnbull and Warrener, was very explicit in his view of the issue. And he indeed referred to the case of Welsh and Stokes, which was a Court of Appeal case of a girl falling off the back of her rearing horse, landing on the road surface. Court of Appeal, Lord Justice Dyson saying quite clearly that in those circumstances, injury was likely to be severe if you fall from such a height. But in Turnbull and Warrener, Lord Justice Lewison had this to say: almost anyone who's ever ridden will have the experience of having fallen off a horse, getting up and remounting the horse. I do not with respect regard it as self-evident that a rider who falls off a rearing horse, or for that matter a cantering horse, is likely to suffer severe injury. So consideration of whether injury is likely to be severe can be very much open to question if a claimant is pursuing that particular argument. And a defendant can attempt to use statistics, which has not hitherto been successful in this area, and it generally falls to the impression of the court as to whether or not injury is likely to be severe in the particular circumstances of the case. And I've listed a few other cases which are relevant. The case of Lynch and Ed Walker racing was a case where the court found that it was not proved that injury was likely to be severe or was likely to occur. This was a horse out on the gallops, which whipped round along with several other horses. They all whipped round and the horse fell over. And the evidence was that in normal circumstances, riders can actually dismount as the horse is going to the ground in such circumstances, and that injury and severe injury was not likely. And on appeal, the judge's decision on that was upheld. Another couple of points which are worth making at this point, that the behaviour with which one is concerned doesn't have to be aggressive or vicious behaviour on the part of the animal. It can be playful. For example, in the case of Hunt and Wallace, it was a collie dog just running free, running fast as they do, but an unfortunate colliding with the leg of a lady who was visiting the property. It can be simply unreliable and unpredictable. That's the case of Wallace and Newton, which is quite an old case and one of the very first cases in respect of the Animals Act. And it's interesting because the court there found that the horse was unreliable and unpredictable, and was known to be unreliable and unpredictable, and that the groom of the horse's arm was caught between the horse and the horse box that it was being taken into, and in those circumstances damage was likely to be severe. Second point I'll just flag up is that the characteristic which we will come to consider under section 22B in a moment must be the same characteristic that satisfies the limb of 22A that's relied upon by causing personal injury to be likely, or any injury to be likely to be severe. And the important case on that aspect is Bolt and Clark, or Clark and Bolt, it's often called. And if I just give you the facts of that, it may highlight what we're concerned with. Here a horse stepped sideways into the road as a car passed, and it struck the car, causing damage to the car. The judge found that damage was likely to be severe because of the horse's weight, and the Court of Appeal didn't dissent from that. But the problem arose then with using the same characteristic of weight to satisfy section 22B. And the Court of Appeal found that section 22B, which we'll come to in a moment, was not satisfied because the heavy weight of a horse was a normal and ever-present characteristic of the horse species generally. It wasn't abnormal, and it wasn't normal in particular circumstances. The weight of the animal is present all the time. So I flagged this case up just at the moment to reiterate that one has got to have the same characteristic causing injury to be likely or likely to be severe as arises under section 22B. So let's go to the questions to ask yourself under section 22B. So if you're seeking to rely on the first limb of A, the question becomes, was the likelihood of personal injury due to characteristics of the animal which are not normally found in animals of the same species? So it's an abnormal characteristic for the species. Or, second limb, was the likelihood of personal injury due to characteristics of the animal which are not normally found in animals of the same species, except at particular times or in particular circumstances? If you're relying upon the second limb of A, firstly, was the likelihood of damage being severe due to characteristics of the animal which are not normally found in animals of the same species? So again, abnormal characteristics, the first limb under B. Or second limb of B, was the likelihood of damage being severe due to characteristics of the animal which are not normally found in animals of the same species, except at particular times or in particular circumstances? So let me spend a bit of time now just dealing with the meaning of B, because there was considerable confusion about the precise meaning of B and whether alternative limbs were being advanced by B, or whether what I call the second limb was simply additional to the first limb. And the case of Merber, Heady and Henley in the House of Lords resolved that particular question and decided that there were two alternative limbs, the first being where the characteristic of the animal is one which is not normally found in animals of the same species. So this is an abnormal characteristic for the species, and so it applies, for example, to a horse which goes around biting people. That's abnormal for the species, and there would be potential liability for it, given the abnormality of the characteristic under the first limb. The second limb, which is much more prevalent and more often used, is where the likelihood of damage being severe or of personal injury occurring is due to characteristics of the animal which are not normally found in animals of the same species, except at particular times or in particular circumstances. In other words, the characteristic is a normal one for the species at particular times or in particular circumstances. And the common example is the bitch with puppies. The bitch will bite to defend her puppies. She will act aggressively in defence of her puppies. In those particular circumstances, she will bite. If she did not have puppies, in normal circumstances, she wouldn't bite at all. It's only in those particular circumstances that she does it. Another example is a horse rearing because of some adverse stimulus in front of it, which is frightening the horse. Another one might be horses bolting because they're in fear of something that is in their flight zone behind them. They will run regardless of obstacles in their path if they are frightened and seeking to flee from the adverse stimulus behind them. So I hope that gives some examples of how the criteria in the second limb of B can be met. So you had in Merberheady and Henley horses fleeing, breaking down fencing, going through a hedge and going a considerable distance along a minor road to get to a major road, where the horse was then frightened by lights of cars. That this occurred at night on the road, and there was a collision between a car and the horse. In the case of Cummings and Granger, the guard dog biting somebody gaining entry to the scrapyard. In the circumstances of defending its territory, then it was normal in those particular circumstances for the Alsatian to behave as it did. Likewise, Curtis and Betts, the dog in the rear of the car defending its territory, normal to bite in those particular circumstances. Flack and Hudson was a case under the first limb where the horse, which was being ridden by the claimant, was frightened by all agricultural machinery, and the horse bolted and she was thrown from the horse and suffered injury. So that's the first limb. Welch and Stokes was a case of the horse rearing and the rider falling off. The horse reared in the particular circumstances of being frightened by something in front of it. Freeman and Higher Park Farm was another case of a horse bucking before it started to canter. That was a case in which the court found actually there was no characteristic of horses which was either abnormal being demonstrated by this horse or which were normal in particular circumstances. No expert evidence had been called, and so the court at first instance found that section 22B was not satisfied, and that was upheld by the Court of Appeal. The case of McKenney and Foster is a very interesting case because this is a case where a cow, having been weaned from its calf that day, leapt over a 5-bar gate and then proceeded to leap over a cattle grid and got onto a road where an accident occurred. In normal circumstances, one might think, well, that's a prime example of an animal behaving in a normal way in a particular time or circumstance, namely when having been removed from its calf, when its maternal instincts were at its highest. And in those circumstances, a cow is highly likely to pursue the maternal instinct to try and find the calf. But in McKenney and Foster, the Court of Appeal did not pursue that route all the way. They said the behaviour of the animal was so extreme that it was not part of the normal characteristic of a cow in the particular circumstances of having been weaned from its calf. And so liability was not established under section 22B, and I think that case just shows what fine lines there can be. There is no doubt about it that ever since the case of Merberheady and Henley, a lot of courts have been unwilling to find liability upon, for example, a farmer in this case, where there is no negligence of any kind at all, and it's considered to some degree unfair to expect a farmer to accept liability and to take on board liability for an exceptional kind of case such as this. So McKenney and Foster does stand somewhat alone, but it is an indicator that there is a defence available to a claim under section 22B where there is extreme behaviour on the part of the animal. So let me move on now from B and turn to section 22C. Was the relevant causative characteristic known to the keeper? Well, if we're dealing with an abnormal characteristic, it is critical that there will have been a prior incident in which the characteristic has been manifested by the animal, such that a claimant can say, you, the keeper, knew about this abnormal characteristic because it had been exhibited by the animal on a prior occasion. When one comes then to the second limb of 22B, and one's dealing with a normal characteristic of the species, so let us say the characteristic of a horse to rear if it sees an adverse stimulus in front of it, something that frightens it. You may well have an owner or the keeper of the horse who says, I have never ever had this horse rear before, therefore I don't know of this characteristic in this horse. Well, unfortunately for the defendant, that is not sufficient. If the keeper of the horse knew of the characteristic of horses to rear when frightened by something in front of them, and that their horse, as a horse in general, was capable of manifesting such characteristic, even if it hadn't done so before, then that amounts to knowledge of the characteristic, which is sufficient to satisfy section 22C. And the case there is the case of Welsh and Stokes. In the case of Merthyr, when it was in the Court of Appeal before going to the House of Lords, Lady Justice Hale had said that the keeper only has to know of the existence of the characteristic and not of the existence of the circumstances which give rise to the manifestation of the characteristic. So, for example, in the case of Merthyr, the horse is fleeing, providing the owner of the horse knows about the characteristic of horses to bolt when in flight from something behind them, then they don't have to know about the fact that there were circumstances which created that fear at the time that the incident occurred. So the critical thing to take home from that really is that under section 22C, the requisite knowledge can be actual knowledge of the actual characteristic having been manifested by the animal before, or general knowledge of the fact that the species has the characteristic as a normal characteristic which may be manifested at particular times or particular circumstances. The reality is that because of the need for actual knowledge of an abnormal characteristic, it's much more difficult for a claimant to get home in such circumstances, because the claimant has to prove that the keeper did have prior knowledge of this abnormal characteristic in the animal, whereas it's much easier to say that an owner of a horse, or indeed of cattle or of dogs, know that the animal behaves in a particular way in particular circumstances because they're experienced owners of dogs. A claimant might be unfortunate, for example, if an accident occurs within about a week or so of somebody owning a dog for the very first time who knows nothing about dogs. It might be more difficult to prove that that person had a general knowledge of the particular characteristic of dogs to behave in a particular way in particular circumstances. The case of Merva Heady definitely caused a number of people to be concerned about what appeared to them to be an extension of the liability which arose under the Act. And that has led to a much greater focus upon the statutory defences at Section 5, which can be utilised to try and limit the extent to which liability will arise under the Section 2.2 of the Act. And there are two primary statutory defences which I'm going to deal with. The first is Section 5.1, which says that a person is not liable under Section 2 to 4, so let's ignore 3 and 4, under Section 2 of this Act for any damage which is due wholly to the fault of the person suffering it. Now, that might arise in a number of situations, but one has to highlight the word wholly. This is not contributory fault. This is fault due wholly to the fault of the person suffering it. In Cummings and Granger, again, the Alsatian attacking somebody going into a scrap yard where there's a notice on the door and you go in, then obviously there's a real risk that it might be due wholly to your fault. In the case of Turnbull and Warrener, where the rider of the horse, who was present together with the owner of the horse, the rider wanted to canter just at the end of a session in exercising the horse when it was using an unusual bit for the horse. And the owner said, do you want to do this? And the rider said, yes, I want to do it, despite the fact I know it's an unusual bit for the horse. And duly, she fell off the horse because of the impact of the bit when she was cantering. But she was bringing a claim under the Act where there was responsibility which lay with the defendant, even though a lot of the fault was hers in wanting to go to canter the horse with the bit after the end of the session. So the fault was not wholly the rider's fault, because it was in fact shared. The case of Richards and Richards, which is a first instance decision of a farmer following behind his cattle when herding them into a barn. He was too close behind them, such that when a bullock kicked out with both rear legs, hit him in the chest, causing him to fall to the ground and crack his skull on the concrete surface of the yard, it was wholly due to the fault of the farmer as the claimant, because there was nobody else at fault. He knew that he shouldn't be too close to the cattle, and he was too close to them. So it's a question of really concentrating on the word wholly. Is somebody else to blame, or is it wholly the fault of the claimant? It's right to point out, though, that contributory negligence is still an available defence. So even if one cannot succeed as a defendant in establishing under Section 5.1, then contributory negligence is still available. Next slide, Section 5.2 is a much more applicable defence in many cases. A person is not liable under Section 2 of this Act for any damage suffered by a person who has voluntarily accepted the risk thereof. Now that may well sound very much like Valenti to you, and it is quite similar, but the Court of Appeal in the case of Cummings and Granger went to lengths to state that the words are to be given their natural meaning, and it must not be confused with Valenti. The defendant must simply show, firstly, that the claimant fully appreciated the risk, and secondly, that the claimant exposed him or herself to that risk. And the defence was further addressed in the case of Goldsmith and Patchcott, where the claimant was riding a horse with the intention potentially of purchasing the horse if she liked it. She was a very experienced rider. She knew that horses could rear or buck. She would feel herself, due to her experiences, able to cope with a horse bucking or rearing. And in this instance, the horse bucked so violently and reared so violently that she fell from the horse, and then unfortunately she had her face stamped on by the horse, which caused significant damage to her face. And a claim was brought on her behalf and succeeded under section 2.2. And I was acting, in fact, for the claimant in that case, and I was pretty confident that section 5.2 would not work. But the Court of Appeal took the view that the violence of the bucking and rearing, which was unexpected by the claimant, did not diminish the effect of section 5.2, and given that the claimant was an experienced woman, she knew of the risk of a horse bucking and rearing, and the fact that the bucking and rearing was so violent did not alter the fact that she knew of the risk and exposed herself to it by riding the horse. So it's a very important defence for defendants, and claimants have to be very careful about how they proceed in the light of it, because if the defence is established, it means that no liability arises under section 2.2. Lord Justice Jackson in Goldsmith and Patchcott used the phrase, well, if I read the passage, if the claimant, knowing of the risk which subsequently eventuates, proceeds to engage with the animal, his or her claim under the Act will be defeated. Now, those words have been used in certainly one case that I know of, and it has been used in others, certainly as an argument, to say that if there is no actual engagement, so if somebody attends, for example, a stable yard, and a horse, through no involvement of the claimant, suddenly bolts and knocks the claimant to the ground, then the Act may well not be applicable, or section 5.2 of the Act may well not be applicable, because the claimant would not have been engaging with the horse simply by entering the stable yard. So that's an important aspect to bear in mind. An interesting example of the section 5.2 defence arose in the case of Presky and Sutcliffe, which was a first instance decision. This was where there was a dog in a pub owned by the publican, and there was a delivery to the pub, and the dog ran towards the door through the pub, and somebody who was visiting the pub, who was a regular as I understand it, grabbed hold of the dog between his legs and held on to the dog to stop him going through the door, and the dog bit him. And section 5.2 was found to be applicable because the claimant had himself grabbed hold of the dog, so had engaged with the animal, knew that dogs, being territorial animals, might bite when on their premises, and in those circumstances the claimant fully appreciated the risk he was running and exposed himself to it when he grabbed the dog and restrained it. So section 5.2 applied. The caveat to be placed on section 5.2 is at section 6.5, that where a person employed as a servant by a keeper of an animal incurs a risk incidental to his employment, he shall not be treated as accepting it voluntarily. So that is certainly of significant import when one is dealing with jockeys or grooms who work in riding stables, who are employed by the stables or by trainers. And in those circumstances, it's not open to the defendant to say that Section 5.2 applies. There may be some argument about whether a person is a servant. That's quite an old-fashioned expression, and in fact it was addressed in the case of Richards and Richards. So that's a possible point that can arise. Time is passing, so I've got one further aspect which I want to deal with, which doesn't actually apply to the Animals Act. It's the issue of negligence, which arises in particular cases involving dogs. And I just wanted to highlight it because it's the case of Whippy and Jones, which many of you may know, which involved a dog off a lead, which went up and frightened somebody who effectively fell down a slope and sustained an injury. And Lord Justice Aikins in the Court of Appeal set quite a high bar, relying in large part upon Lord Reed's judgment in Bolton and Stone. Now, there were some complications with Whippy and Jones, which I'm not going to go into, but the test set out by Lord Justice Aikins is still applicable in other cases, because the test was adopted again by the Court of Appeal in a subsequent case of Addis and Campbell. And I just want to read through, if I may, the passage of Lord Justice Aikins' judgment. The question of whether a person has acted negligently is not answered simply by analysing what he did or did not do in the circumstances that prevailed at the time in question, and then testing against an objective standard of reasonable behaviour. Before holding that a person's standard of care has fallen below the objective standard expected, and so finding that he acted negligently, the court must be satisfied that a reasonable person in the position of the defendant, i.e. the person who caused the accident, would contemplate that injury is likely to follow from his acts or omissions. So the word likely, which is not to be confused with the use of the word likely in the Animals Act, but the word likely sets a high bar for the issue on the issue of foreseeability. And it goes on to say, nor is the remote possibility of injury enough. There must be a sufficient probability of injury to lead a reasonable person in the position of the defendant to anticipate it. Now, the last sentence may slightly ameliorate the extent of the word likely, but it is clearly a high bar of foreseeability which is being set, which one might argue is slightly different to how high the bar is in other areas of the tort of negligence, but clearly in respect of animals and dogs in particular, the case of Whippy and Jones is of considerable importance and relevance. So I just wanted to flag that up for you. That's all I've got to say at the moment. There is a question which I have here from one of you. Would a stallion trying to mount a horse being ridden be likely to fall under section 22B? Yes, I think is the answer, because in the particular circumstances of a horse wanting to mount another horse, then the animal is going to behave in a particular way. And in those particular circumstances, it may well be that there is a risk of injury, query whether it's likely, query whether it's likely to be severe. I honestly don't know the answer to that, because I haven't had, that I recollect, a case on that particular basis. But I certainly think it potentially falls under the second limb of 22B. Another question, when assessing voluntary acceptance of risk, is it sufficient for the defendant to merely mention the risk? For example, in the case of a child, would it be expected that they will have a lesser appreciation of risk? Yes, I think the answer is with a child, it would have. The fact that a risk is mentioned, I mean, what one often has it in the case of riding stables, where they put on a brief written form or on a contract that riding is a dangerous sport and injury can occur, and the potential rider is asked to sign it. It's obviously a factual element which is important, and a defendant will rely upon that there is such an apparent acceptance of risk. Whether it'll succeed every time is open to question. It's going to be a matter of fact in each particular case. A case I've done very recently, the claimant was leading a horse back from it having escaped, and whilst he was leading it back, the horse bolted and knocked him over in doing so. The judge took the view that section 5.2 did not apply, even though the judge accepted that he was a very experienced horseman, he did not accept that he voluntarily accepted the risk of that happening whilst rescuing a horse and bringing it back to the field in which it had escaped from. I think that goes to show the difficulty in these cases often. Exactly how a judge is going to approach it and the view he's going to adopt. It would be very easy to see a different judge taking a different approach to that particular question. Let me just check whether I've got any more. I've got a question: how experienced would one have to be in terms of riding a horse for the volunteering defence to work? Well, again, I think it's a factual question. What is the extent of your appreciation of the risk? What do you know about horses? Do you know that horses can buck and rear in particular circumstances, for example? Do you know that they can bolt in certain circumstances? So if you know and understand those risks, then you are subject potentially to the section 5.2 defence. But again, I think I have to reiterate, really, it depends on each particular set of facts. Right, I think those are the questions that I've got. Can I flag up two things? Firstly, Emily has put up in the Q&A where to give us some feedback. It'd be really helpful if you could give us some feedback. It's much more difficult getting feedback seemingly from attendees when we're doing webinars rather than when you're in the room with us and we can stop you leaving without having done something. So we'd be very grateful if you'd do that. The other thing is, can I flag up that on our website is our next webinar, which is on the 26th of this month by Justin Valentine, relating to shoulder dystocia, which, having looked it up online, I find is a complication of childbirth. So if you're interested in that, please go and look on our website. Thank you very much indeed for attending. I'm very grateful for you to having sat there, listened, and I apologise if for some of you it needs a damp towel to go over your head at this point, having listened to some of that, because it can be quite abstruse at times. But I hope you've gained something from it. If anybody has any questions further, my email is at the back. You're very welcome to contact me and ask any questions you might have. Thank you very much indeed. Goodbye.